When did you come last, Saurav, on my channel?
Uh, I think it was a very a happy occasion for journalists, as I remember myself saying at that point. But things were not in a great state. I think this was about a year ago, maybe.
A year
Yeah,
ago, I think. Yeah, I was
yeah.
also
There was a
thinking.
big event happening at that time.
I think
Something
we
going on.
did a similar state of the judiciary thing only then
Yeah,
also. I
yeah,
remember.
yeah.
But now you have had an entire year of experience, and also you have done a kick-ass piece on Justice Chandrachud. So,
Oh, yeah.
by the way, guys, just in case you don't know, and I will leave a link below in the description when the video goes out. Saurav Das here has done an intense piece in Caravan, a profile piece about Justice Chandrachud. And this is insane timing because Justice Chandrachud is currently doing the rounds of the media. And the other Saurav from Lalantop happened to mention Saurav's piece in front of Chandrachud also. What is the reception? Also, please tell us about the piece in general for those of people, those of us who don't know.
So this was a profile that of the former Chief Justice of India, D.Y. Chandrachud, who was once upon a time a favorite of the Indian liberals, elite class liberals, but ultimately fell from grace because of all his deeds during those 2 long years as Chief Justice of India. So I worked on the profile for 3 to 4 months, spoke to over 40 people, trying to understand who this guy is, what are his motivations, and why he did what he did during those 2 long years, and even before he actually became the CJI. Even as a judge of the High Court, as a judge of the Supreme Court. So. It was a long ass piece, 16,000 words. The
Yes.
original draft was 29,000 words. So there's a lot which was not said in that 44 pages in the caravan, but yeah, it turned out well. A lot of people really appreciated the amount of work that I put into that piece,
Oh,
and it
you
had a
had put in a lot of work, by the way. Also, so right now, Justice Chandrachud has released a book.
yeah.
I saw your photo. You were holding Justice Chandrachud's book, looking at it longingly. You're clearly obsessed, bro. Like,
No, Chandrachud is someone who, I ever so often come across either his writings or his interviews or people mentioning him in the passing. So it's like he is not leaving me and I am unable to leave him for some reason. And I so really want to leave that chapter forever now, but it's not happening.
but
But
you
I
got the
think because he
book.
was in the news, I came across that book, so I thought it's a nice picture to put and an excerpt from my profile of him.
या खुद का सेल्फ प्रमोशन ही करना था तुझे.
Self
सीधा
promotion
सीधा
करते
सेल्फ
हैं.
प्रमोशन करना था. Chandrachud is just an excuse. But did you get the book?
I did not.
Wow. Okay, that's.
Probably. I mean,
I did
yeah,
not.
probably at some point I'll lip gen it.
Yeah, yeah. Oh, you lip Janet. Okay, fair, fair. But tell me, so I was watching interview of Chandrachud in News Laundry with Srinivasan Jain Abhi. Super combative. You haven't seen it yet.
I
Um,
haven't.
so one of the things I noticed, and I think you covered this in your profile piece also, Chandrachud was not the usual CJI, right? He's not the usual person who keeps away from the media or does not give like statements like a judge or whatever. And even now, when he's retired, what 9 months ago, even now he's combative. Even now
Yeah.
he's like giving like like as they call it, what shagufe or something in Hindi, right? But
Yeah.
what is your general idea of Justice Chandrachud as a CJI?
Yeah. Um, I mean, he was definitely a judge who was super media savvy. And I remember in 2018, 2019, when he gave his very beautiful, famous dissents on the Bhima Koregaon case, and matters related to adultery and money bill, all of that. The dissents were beautiful. It was a dissent for the future, as many people called it. So I remember the Indian liberal media, writing pieces about him, calling him a rock star judge and all of that. So the media actually hyped him up as this, person who would revolutionize the Indian legal system, and therefore the media was quite responsible for getting people's hopes up. But clearly, because of his, media savvy nature, that also was responsible for his downfall. By the end of his tenure, of course, his actions were, but then that constant requirement to be in the media, to be in the news, even after retirement, I think that really came back to bite him ultimately.
But do you
So
think, no, one thing I have to ask you here, do you think the new kind of judges, the new era of judges is like this, which is like Chandrachud and what he does, which is they are very responsive to the media, they're talking to the media all the time, they're giving
yeah.
statements, or do you think there is something fundamentally wrong about this?
I mean, social media revolution and all of that. We can't really comment on how judges were before, say, 2014,
Hmm.
2015,
Hmm.
when social media was not that big. But now that social media is big, the Supreme Court has a dedicated PR cell. There are people dedicatedly working on, press relations and all of that. So I think the judges are also unable to sort of keep away and be aloof from
Yeah.
all of this. So clearly, after Chandrachud, I mean, Chandrachud took it to the most extreme possible, because
Yeah.
he, as a sitting Chief Justice of India, he kept giving interviews to NDTV, to PTI, went for so many lectures and on the sides giving his bites to the media.
Hmm.
But other Chief Justices since then have also, except Sanjeev Khanna, who
Yes.
hasn't, talked to the media even after his retirement. I think all the others have been very friendly with the media and sort of try to project themselves in a certain manner,
Hmm.
even if their actions didn't, match with what they are saying to the press or in
Actually,
public.
very interestingly, there was this recent hearing that was happening, I think, about the ED, right?
Yeah.
Where I think the Solicitor General, or Attorney General, or one of the two, he basically asked the court not to give any adverse comments about ED because it goes crazy on social media or something. Like the media
Yeah.
picks it up, and so they are very in tune with the public opinion on social media, etc. So it does make sense now.
Yeah, absolutely. Because the I think the fundamental need to actually project yourself as this very liberal and upright person before the media comes from the fact that you are actually not living up to those standards in court, inside court, in your actions.
Hmm.
So, and hence the need to always go out in the media and give all those lectures and project yourself as something great. So I think that is a fundamental wrong with today's chief justices, and especially chief justices, because judges ko to kaun utna zyada media does not, it doesn't carry the same weight as a CGI statement to the media.
Plus,
So
it's also always seen as like an institution is speaking, right? Whenever they
yeah.
give judgments, whenever they speak, it's like, oh, the court is saying things. It's the individuals don't really matter.
Yeah, exactly. But there are two. I mean, the media that I am talking about is out of court. What the
Hmm.
judges do in lectures, in public lectures, etc. But what the Solicitor General said in court about about the judges' comments about the ED percolating through the media, especially to the lower courts, and sort of influencing the orders that these courts are passing. That statement came on the basis of the judges saying things on the basis of the facts of the matter before them.
Hmm.
So those are oral remarks. They don't carry the force of law, but then they do influence and give us a fair view of how the court is thinking about a certain case.
But
So
actually, I would actually a little bit disagree here because I have seen so many instances now, especially in the recent past, where the court is asking questions. Like, so the judge is, let's say, a case is happening, and they're always combative from the other perspective, right? Which is like,
Yeah.
if you are a defendant, then they will be arguing the prosecution's questions, and then if
Yeah.
you're a prosecution, you will be asking the defendant's ka questions.
Yeah.
In case, for example, the Bihar SIR, right, they
Yeah.
were asking some very combative questions even to the government, and they were asking some combative questions even to the EA. What
Yeah.
tends to happen now is that those statements are picked up, and what judgment ही दे देते हैं लोग, as if the court has already decided that this is what
Yeah.
is going to happen.
Yeah.
Honestly, it's so strange, because like I remember even in the Bihar SIR thing, I think the bench only asked questions about, oh, should Aadhaar be a document or something. Godi media ran like full on headlines saying that, oh, like petitions defeated, Rahul Gandhi's what chori allegations defeated, kuch bhi
Yeah.
pe le jate hai.
So I mean that's the problem with social media and people who don't closely follow the courts, because it's an adversarial system after all. You
Exactly.
need to cross question, you need to play devil's advocate to get the best, the purest argument out of the counsels before you. So to extend that to say that the judge is thinking in a certain way and take it as a judgment is entirely wrong. I think over time people will realize that ये सब बोल बच्चनबाजी से कुछ नहीं होगा. Ultimately, the court will decide, and whatever it decides, it has to be in writing. So I think that's something, it's a process,
Yeah,
and people are just getting used to live streaming and
Oh,
live
actually,
tweeting
one
and
of
all
my
of that.
members had a question about that.
Yeah.
The live streaming bit, what do you think about that? Is that a good idea, or do you think it makes people more performative now?
Playing to the gallery, I think judges have been doing that for a while,
Yeah.
honestly. Even before live streaming, they would perform for the people sitting in the courts, for the advocates sitting in the courts. Now they are doing it for a larger audience. I think a judge who is true to his oath would do justice to the case, right? Even if it requires some amount of performance or whatever. A true judge would actually decide on the merits of the case and not be influenced by who's saying what on social media and who's watching. So I think it's an experiment which is ongoing. Let's see, because I think live streaming, the
Now it
Supreme,
doesn't happen that often, also.
no, live streaming in the Supreme Court of regular cases is not on, only of constitutional
Constitution benches.
benches.
Huh, huh.
Although video conferencing happens, so sometimes people, record and post snippets of it. But there are high courts that live stream all their proceedings in general, except say a very
Which
sensitive.
ones do it? Which ones do it now?
So Jharkhand High Court does it.
Okay.
There are several other high courts. I think Chhattisgarh High Court also does it. But the high courts have also been very hesitant to adopt live streaming. Because I mean, like now we are getting into speculation and all of that. Judges get exposed
Yeah.
because you then see the quality of judges in our high courts.
Yeah, that's
Uh,
very true.
Therefore, judges are very hesitant to adopt this kind of technology. And it's surprising that the Supreme Court was the one who gave the judgment on live streaming in 2018, but till date hasn't adopted live streaming for their regular hearings.
Yeah, I think it should happen. Honestly, I loved watching the Supreme Court whenever it's live. I love
Yeah.
watching the Constitution benches also.
Yeah,
Because,
and it brings people closer to the system because we don't
yeah.
have system as well. So people are not really aware of how the system functions, and judiciary is really an important organ.
Right.
And I think even if people watch it as a pastime, it's great. It educates them to some extent.
Also, the legal arguments are very complicated. I mean, most people
Yeah.
won't understand what is happening, but still,
Yeah.
just to sort of see how it happens, or what is going on, or some bits
Yeah.
and pieces you still understand, right? So it's
Exactly.
fun to watch.
Exactly. Yeah.
Okay, just to begin with, let me just start with a meta comment from you. मुझे बताओ, what do you think about the state of our judiciary right now? What are the things that you're happy about, and what are the things that worry you?
I think from the ever since we spoke last on your channel, things have gotten significantly worse.
Okay.
I mean, there were some good moments, the staying of the Waqf provisions, which were blatantly unconstitutional. There were a couple of other moments, I'm sure I can't remember, Abhi. But then mostly, if you talk about appointments of judges, if you talk about bail cases, and everything else, I feel the system is becoming more and more blatant in its actions, and actions which are not really great. So there are constitutional matters that are still pending in the Supreme Court. There are appointments of people with doubtful integrity, happening, and quite blatantly so. Even if there's so much criticism and talk in legal circles about it, the appointments are still ongoing. There's enough executive interference with the appointments process. Transfer of judges are not happening. Transfers of some good judges are happening for some reason. I don't know why. So, in terms of administration of justice, the larger judicial reforms that are required, things are still in the same situation and only deteriorating.
So
Uh,
collegium in general is as usual, not functioning
as
properly.
usual, and not as usual. I think that is where the most amount of damage is happening, and it has gotten significantly bad in
Why
the
do you
past.
think why do you think that is happening? Because honestly, like in my head, as a commoner who is observing just institutions in general, my idea was that let's say the Modi 2.0, which was there, a brute majority, kafi power, so institutions usually like lean towards whoever is in power, right? I mean, so
Yeah,
legislation, panga nahi lena hai basically. Abhi nahi
yeah.
panga lena hai. But
Huh.
now, since in year, and we spoke last in March, I think, March 2025, so before elections, March 2024, my bad.
2024.
Yeah, yeah.
Yeah.
So what I want to understand is now that Modi is 240, he is
Yeah.
not that powerful. It's a coalition government in power. My idea would be that situations would improve, like institutions would actually start functioning better because the legislature is not that powerful. You don't have to be that fearful anymore.
Yeah.
What has changed in the last 1 year?
The issue is, I think, and credits to the government for this, because they have projected Modi 3.0 as a continuation of Modi 1.0 and 2.0.
Correct, yeah.
So even if you see a parliamentary process which you follow more closely than I do, of course there are bills going to parliamentary committees and all of that. But is there something very significant happening in those committees, or is the
Not
government
really, you're right.
relenting?
Hmm.
So I think it's really a continuation of what has happened, and therefore the courts have also picked up on this, and the court, functions in a certain manner, in the sense there is a sense of continuity. This is the only institution that is gonna have this chief justice in 2031, this chief justice in 2029. So there is a continuity in the institution. Now the judges that have been appointed under Modi 1.0, Modi 2.0, because the last batch of judges that were appointed during UPA 2 retired in 2018 or 2000, early 2019. So since
Interesting.
then, there have been only Modi government appointed judges. So there's a sense of continuity there, because the judges are already there, and those are the judges coming to the collegium and making decisions on appointments and
Wait,
transfers.
so Modi appointment, again, like a bit of a distinction. So collegium is the one that is appointing, government is recommending, right? Or do they have like a real influence on the
The
collegium?
collegium is the one recommending, and the government is the one that finally approves and appoints, and the president appoints
But
on
the
the.
collegium doesn't have to listen to them, no?
They don't have to listen to them. The very initiation of the process starts at the collegium level. So if
Correct.
the collegium does not recommend Meghnad, the government can't do anything about it, because there's no file before them, right? But what happens is, and that is what I wrote in the Chandrachud piece also, is that now there is an institutionalization of an extra constitutional body, which is basically people from outside the government or within the government actually going up to these collegium judges and telling them that इसको बना दीजिए, इसका फाइल भिजवा दीजिए, इसको आप recommend कर दीजिए. And there's a lot of give and take happening within the collegium system. Now, that is one very huge issue, because then you have these extraneous considerations coming to play, and there are people with questionable integrity, questionable competence being recommended by the collegium, and the government quickly acting on those files.
Oh
जल्दी
shit.
जल्दी appointment हो जा रहा है उन लोगों का, and that is a huge issue.
Hmm. So essentially, the collegium is recommending the people that the government wants, and the government is accepting those people quickly, and then the collegium is
Exactly.
appointing those
This
people.
is happening because the government appointed those very collegium judges in Modi 1.0 and Modi 2.0.
Right. Oh, correct, correct, correct. So like it's like the because of the continuation, now we are seeing like a whole host of Modi
Yeah. Now,
appointments coming in.
yeah. And because things have not changed so much in Modi 3.0, or at least that's what it's being projected,
Fair.
things will not change so much also, right? Because you saw the recent appointment of Vipul Pancholi, who's a Gujarat High Court judge, was Chief Justice of Patna High Court until elevated to the Supreme Court. He is going to be the Chief Justice of India in 2032, if I'm not wrong.
Oh my
Now, I have
God.
been extensive. Yeah.
Oh God, that's horrifying to think about. It's just
No,
like
what is more horrifying is I wrote an entire piece on him and other appointments that the collegium just did, because he was recently recommended. Uh, there were very serious questions of integrity surrounding him, you know.
tell us about him.
And yeah, so he's a Gujarat High Court judge. Back in 2023, he was recommended for transfer to the Patna High Court,
Okay.
because there were some adverse inputs from coming from that High Court to the Supreme Court Collegium, and the Supreme Court and the government was not acting on a batch of transfers from Gujarat High Court. There are still 4 judges who have till date not been transferred, because the government is adamant and sitting on their files despite the collegium recommending their transfers. But on Vipul Pancholi's transfer recommendation, the government sat on it for 9 months until it finally relented, because the collegium was strongly, asking the government to transfer him. Now, it recommended the transfer because there were unresolved questions of integrity. There were serious complaints against him. Now, अब हमारे सिस्टम में क्या होता है, instead of investigating, instead of suspending, instead of impeaching, transfer कर दो, as if that resolves
Yashwant Verma.
anything. यशवंत वर्मा को जैसे for example, Yashwant Verma is still one of those cases जो impeachment motion is in
It's
progress in the
pending. Yeah.
parliament.
But
But
that
there
also
are
happened because it came in the media.
it came in the media and was super blatant.
Yeah.
The people's faith was shaken in the judiciary. But what about these, insider information that the Supreme Court judges get, the collegium gets? So all that they do is transfer कर दो. अब transfer करके कहाँ भेजेंगे? अच्छा, पटना हाई कोर्ट भेज देते, because there is no industry there, there is no mining there is no chances of making big money. तो भेज दो उस हाई कोर्ट में, so they'll eventually they can't be making a lot of money there. So ऐसे करके they make the transfer decision. So I think something similar might have happened in Pancholi's case, but there were adverse inputs about him, and he got transferred in 2023. Now 2025 May महीने में the government was very adamant on bringing him to the Supreme Court. But the fifth collegium judge, Justice Nagaratna, who is known to be very independent,
Yeah, she
strong.
dissented on a bunch of things. Yeah.
Yeah, she dissented also recently, and back in May also had dissented on Pancholi's elevation to the Supreme Court. His candidature was dropped for a few months, but then the government again, brought his candidature back in the process, and then he ultimately got elevated to the Supreme Court. So, if you have a Chief Justice of India in 2032, and our judicial system is so hierarchical, it's a caste system on its own.
Yeah, yeah,
The Chief Justice of India is the most powerful, institution, an institution on his own. So 2032, when a person like that is appointed, is heading the system, what kind of people will be appointed for 2040, for
yeah. Right.
2041?
Correct.
So it's a continuation, and we have these kind of judges, So it's a sabotage if you think about it that way. The system is not putting up a fight against a strong executive, and that is a concern that not just me, but senior advocates, people in the profession, retired judges have been crying hoarse over this for the past
Again,
few years.
that's again one more thing. Retired judges बहुत बोलते हैं. Like
Uh,
retired judges are the ones who actually say things about institutional reforms, etc. But is
yeah.
there currently any noise you hear, and this is what chat is also wondering, about reforming the collegium system or putting reforms in the judicial system in general? Is there any interest at all in the people in power? To chhodi do, but at least even within the judiciary.
Within the judiciary and even with so the collegium system is a great setup. It's working to the best of its abilities right
Yeah,
now for both the sides.
yeah.
So the collegium judges are getting their
And
own
I
set
think
of
you
people.
mean this sarcastically. I mean, yes,
Sarcastically,
yes.
absolutely.
Yeah.
Now, the collegium was created in the 1990s as a promise to safeguard the independence of the judiciary. Far from that, what we are seeing now is a very cozy system between the executive and the judiciary, where people from both sides are getting their own people appointed. It's a give and take. आप इसको appoint कर दीजिए, आप उसको appoint कर दीजिए. Now the question is, who is the most evil amongst that? So maybe there are some collegium judges who put their foot down and say that no, this guy is honest, this guy is of great integrity, we need to bring him into the system. But those are just one or two judges that eventually make it to judgeship. But far too many people of questionable repute are being appointed from both sides of government. So such a system where everything is hunky dory for both sides, nobody wants to reform that,
Correct.
right?
Correct.
And the bar is supposed to be the mother of the bench, right? They are supposed to raise concerns and invigorate the system from within. But the bar is completely dead. The Supreme Court Bar Association did not do a chew when Justice Pancholi was being elevated to the Supreme Court. So the bar does not speak.
Even with the Yashwant Verma thing, I don't think the SC Bar Association did anything. I think the Allahabad High Court is Bar Association is the one that
Yeah, there are some High
protested.
Court bar associations that protest. Like, for example, when D.K. Sharma from Delhi High Court was transferred to the Calcutta High Court, the Calcutta High Court Bar Association said, please don't bring him to this High Court because this is not a dumping ground.
Yeah,
Because there were
exactly. A
very
dumping
adverse
ground. Yeah.
remarks about that judge. Ultimately, nothing happened. He's still in Calcutta High Court, but there are bar associations that are far more vocal. But the Supreme Court Bar Association is completely mute on so many issues, and very, I would say, power hungry. Because they don't want to upset the government, they don't want to upset the judges. It's a very hunky dory system. So there's no scope of reforms for the collegium system because the government is happy with it. They are getting their people appointed. Collegium judges are happy with it. They are getting their people appointed. And I think ultimately, my personal opinion is that the government should not even try to reform the collegium system because this government, I don't know, I don't think it has the best interests of the institution in mind
Fair.
at the
They
moment.
did try it in with the NJAC earlier, the National Judicial
Yeah.
Appointments Commission, but that
And that
tanked
was
very
a
badly.
unanimous,
It was.
legislation.
Just for chat, in case you don't know, the first thing that Modi government actually did, Modi 1.0 in
Yeah.
2014
It was his
end.
first legislation.
Yes, first legislation that the Modi government brought in was judicial reform. They wanted to eradicate the collegium system and they wanted
Yeah.
to make a new appointment system which would be kind of controlled by the parliament. Not completely, but kind of controlled by the parliament and the judiciary together. Interestingly enough, they made a constitutional amendment. It was a unanimous thing that all parties agreed with. And then
And
the
states.
Supreme Court, and also states ratified it. And then the Supreme Court came in and said that the change in the constitution that you made is unconstitutional. Like, that's the most bizarre thing ever. So, yeah, reforms, even if the government wants it, the judiciary will not allow it. And clearly now, so everybody is working together and doing
And,
whatever they
and
want.
when I tell you that things have gotten significantly worse, now you saw 9 months ago when Chandrachud was there, there was a fig leaf of transparency, in the collegium's working, because the collegium statements which were coming out about appointments of judges in the high courts and to the Supreme Court, they at least were of 2-3 pages, some basic biodata about the person being appointed. कि उसका एज इतना है, उसका इसमें प्रैक्टिस बहुत अच्छा है, ही इज अ ग्रेट एडवोकेट, whatever. Fig leaf, because it didn't give any great information. There was nothing about the legal scholarship about the candidate, nothing about how many cases they have done, nothing about complaints against them, nothing about landmark judgments about, that they have written, nothing of that sort. But still, some amount of biodata, right? But it has gotten significantly worse, because once he retired and Chief Justice Sanjeev Khanna took over, it was back to basics, which is basically just a one-line statement saying the Supreme Court Collegium has resolved to appoint the following advocates,
Which is
following
such
judges.
bullshit, dude. I mean, see, that is one of the things कि ठीक है तुम्हारा ये system garbage है, मतलब like it's like a self-serving system, and I can say that openly because I don't give a shit. But even then, like at least give us the reasons, no? At least give us the pretend reasons why you think this person should be appointed. And now तो वो भी नहीं कर बीच में हो रहा था, you are saying बीच में there was like more details.
चंद्रचूड़ के टाइम पे हुआ था.
चंद्रचूड़ के टाइम पे हुआ था, हाँ.
Yeah. And then Sanjeev Khanna dropped it. CJI Gawai also has continued that, one-line statements.
It's very disappointing when things like this happen. Okay, I'm going to go to the roster system later, but I wanted to take you through the recent cases because my members, my public, my janta had a lot of questions about a lot of things that have been happening, and you've written about a few of them. So let's start with Vantara, right? If you can just give us the premise of what is going on there.
So Vantara is this great zoo that Ambani's Reliance Foundation has established in Jamnagar, Gujarat. And there have been a lot of investigative reports and activists who've been going to court, filing petitions, and actually challenging the processes that Vantara has been following to acquire animals from all over the world. So there are allegations of wildlife smuggling, and when I was writing that piece, I found out that wildlife smuggling is like top 3 or 4 crimes in the world.
Yeah, it's connected
Yeah,
to
I
money
didn't know
laundering
about it.
also. Yeah.
Yeah, exactly.
I think
Because
it goes this way. It is drug trafficking, human trafficking, and animal trafficking. I mean, animal.
wow,
Yeah,
yeah,
yeah.
and and this is my sheer ignorance. I didn't know about this, but one activist did make me understand that why it is so exotic. Because
Yeah.
if a sheikh has all the money in the world, what would he need? Like, there's nothing that you can give him. But an exotic species, with a very special color, or maybe a snake with certain kind of scale, you give that to a sheikh then. So that's why wildlife smuggling is such a, it's in top three or top four.
Yes, yes, yes. And also,
Yeah,
the thing is, what you said exactly, if you have
yeah,
too much money, after a point, what else can you buy? Right? So you
exactly.
buy a liger, which is a cross
Yeah,
between a lion and a tiger, and then you
yeah,
bring them to places like Vantara, basically. Okay, go on.
yeah.
Go on.
Yeah. Not my
No,
words.
no, no,
So
just
now,
allegedly.
allegedly,
Yeah.
absolutely. Because even when I wrote that piece and when I was talking about it as well, yeah, the allegations of wildlife smuggling, money laundering, paying off smugglers, cross-border, smuggling, Assam, Arunachal,
Elephant
and all that.
kidnapping.
Elephant being kidnapped from captivity, and the processes that they were following, and
Correct.
the government is absolutely with them. So the
Hmm.
clearance processes, violations of import export rules, changes in those rules by the government, all of that were the broad allegations that were leveled against Vantara.
Hmm.
Now, I don't know if those allegations are true. There are people who genuinely believe those allegations have substance. But a person like you and me would want them to come clean, right? And
Correct.
a way for them to come clean would be to get them investigated, right? So my focus when I wrote that piece also on Vantara was on what the Supreme Court actually did when a PIL, when couple of PILs were filed in the Supreme Court asking the court to actually order a probe into Vantara's affairs. Now, if we are a rule following country, we would want our most powerful to also abide by those rules, and given the clout that the Ambani family enjoys, um, we do not want too much concentration of power in their
Sorry,
hands.
can
And
I interrupt just 1 second?
yeah,
So, because when this news alert first came, no, I remember, like I was doing my streams, I covered that. I think me and my community were both wondering कि हो क्या गया है, because it's so unusual for courts to touch people like Ambani in any which way, right? I mean,
yeah,
Adani, we saw the SEBI thing, etc. happening. We'll talk about Adani after this also, but with Ambani also, it's such a rare occasion, no, where let's say a Himal magazine, where Raj Shekhar has done, M. Raj Shekhar has done a very investigative piece on Vantara.
yeah,
That has been like that led to a conclusion where the court is actually taking up a case against a very powerful person.
yeah.
It almost feels like क्या leverage है इसके पीछे, क्या हो रहा है, there is some game happening behind, because this seems so unusual.
Absolutely.
Yeah.
Absolutely. So what happened? So now activists were filing pleas before different high courts, alleging that the elephant from here was taken away forcefully, elephant from there was taken away forcefully. Animals are being, being given to Vantara by the government and these central zoos. Now, most of these high courts actually passed favorable orders for Ambani, right? But I think because there was a proliferation of those kind of PILs and allegations all over, what might have happened is, I don't know, now I might be bordering on defamation, but anyway, there were two PILs that actually came to the Supreme
Correct,
Court
correct, huh.
alleging the very same things and relying on those investigative reports, including Raj Shekhar's Himal report, right? And asked the court to actually form a SIT and get these allegations investigated. Now, very interestingly, the case was first listed on August 14th, right?
Right.
And the bench that heard it, Pankaj Mittal, his roster, if you see, he does not have environmental laws on his roster, and this PIL was categorized as environmental law matter.
Correct.
Now the Chief Justice is the master of the roster. He can allocate any case before any bench. He can constitute any combination of benches to his own preference. So the Chief Justice of India, B.R. Gavai, actually specially allocated that matter to Justice Pankaj Mittal's bench, which itself was suspicious. Why would he do that? What was the need for it when there were more senior benches, senior judges available and having environmental laws in their roster? Anyway, that's his prerogative and he did it. He exercised it. For what reasons, we don't know, we can't ask. Anyway, that matter came on the 14th of August, and the bench actually said, Ki, why don't you go to the High Court? Why don't you approach the statutory
Yeah, yeah.
authorities, Wildlife Authority of India, and Central Zoo Authority, all of that, and get it investigated from them. Anyway, when the bench said this, they said we would still like to hear the matter and proceeded to list it after 10 days. On 25th of August, surprisingly, after a very quick hearing, the bench said that they're constituting a special investigation team
Yes.
consisting of headed by a retired Supreme Court judge, Justice Chelameshwar. Now, Justice Chelameshwar carried a lot of credibility because he was the judge who actually led the press conference, the
Correct.
famous press conference in January 2018, where they alleged that there's a bonhomie between the judiciary and the executive, and country is not in safe hands. Blah blah blah. So they rebelled against their own chief justice, and master of roster was one of the issues there. Anyway, so that SIT was constituted, headed by Chelameshwar, consisted of three other members. One of them a retired chief justice from Telangana High Court. The third one
An
being a
IPS officer,
former
right? Yeah.
IPS officer, Mumbai Police Commissioner, now
Hmm.
retired. And the fourth one was a serving IRS officer.
Right.
Now, this SIT was asked to look into everything,
Yeah.
every possible offense under the sky, they were supposed to look into it. And what the Supreme Court did, and this is so blatant because they said you have 18 days to investigate and submit a report. Now, Meghna, tell me money laundering. 2014 में 2013 में मोदी जी वेंट ऑन अ रैंट सेइंग कि काला धन वापस ले आएंगे, मनी लॉन्ड्रिंग हुआ है। आज तक 15 लाख रुपए नहीं आए हम लोगों के पास। क्या 10 11 साल हो गए, एंड दी सुप्रीम कोर्ट इज सेइंग दैट 18 डेज में इन्वेस्टिगेट मनी लॉन्ड्रिंग एंड फाइंड
Arey,
एवरीथिंग।
dude, like, let alone that, like the story, the Himal magazine story that I mentioned by M. Raj Shekhar, I was talking to him. It took him like close to 6.5 months to investigate that one story. Like, which is
Absolutely.
and also, like, it's insane, right? I mean, if you're thinking about like a thing like Vantara, they have imported animals from like ex drug dealers, they have imported animals from Assam, like they've taken like that, the temple say they have taken that elephant. There
Yeah.
are many things that have taken place in and around Vantara, which are worth investigating.
Yeah.
Apart from the fact that it is right next to an oil refinery and it is in a
Yeah.
desert. I mean, that is another separate matter. But honestly, like,
Yeah.
I mean, so this actually is very a good point you make. 18 days they were given to investigate
Yeah.
this. Huh.
Yeah. 18 days they were given a wide mandate to look into money laundering, import export laws violation, offences under the
Yeah.
Bharatiya Nyaya Samhita, what else? Wildlife smuggling,
Wildlife Protection
violation
Act.
of Wildlife Protection Act, every other act, every kind of offense. Now there were only heinous offences which were left out, rape,
Hmm.
murder, and all
Hmm.
that, right? So now the SIT was said कि 18 days you have liberty to ask for an extension of time if you want to, but 18 days you are supposed to submit a report. Now the SIT quickly started its work. What it did, and the conduct of the SIT is so suspicious, because when you read the SIT and even when you read that 25th August Supreme Court order constituting that SIT, it calls it the Special Investigating Team, but the order and the very first paragraph of the SIT summary report says that it is a mere fact finding body. How can you call it Special Investigation Team when it's a fact
Correct.
finding body?
It's a good point. Yeah. Yeah.
And so that fact finding body was constituted. What it actually did, that SIT, is call for the records from all these central government bodies, the very central government which is in the pockets of Ambani.
Right.
All the statutory authorities were asked to submit import export licenses, their documents. Vantara itself, by the SIT's own admission, gave the SIT 13 volumes of documents.
Yes,
तो
yes.
20,000 पन्नों में 25,000 पन्नों में तो 15,000 उनका ही होगा पन्ना, which
Hmm.
they would have very carefully analyzed and
Yeah.
given to the SIT.
Hmm.
So the SIT was fed all the central records, all the Vantara's records, and basis that, by doing a random check of one of the accusations of animals, they proceeded to give a clean chit. And
So
funnily
you're
enough,
telling me that this what? How many 13 volumes you said, right?
13 volumes of
13
documents. Yeah.
volumes मतलब ऐसे बड़े बड़े thick books होंगे.
हाँ.
They basically gathered them, investigated them all in 18 days.
All in 18 days,
Amazing.
25,000 pages.
Love it. Love when bureaucracy works so efficiently.
So efficiently.
Yeah.
And the SIT even notes in its summary report that they reached out to central agencies, CBI and ED, asking them, ki, do you have complaints against Vantara? If you do, is there any credibility in those allegations? And it goes on to note in its report that the agencies expressed their confidence in Vantara's affairs.
Oh wow, that's so cool. Oh, I want this. Saurav, I want to be so
What
powerful, Saurav. Please tell me how. Like it's
it
crazy.
was a sham of
Crazy.
an investigation or even
Oh,
fact finding. Yeah.
holy shit. So they give the report. So SIT gives the clean chit. But tell me the order that came after that, that last John Doe thing.
Uh, uh, yeah, the
No.
John Doe.
That
I
was
mean,
in.
John Doe
Sorry. I'm sorry. That was in
Adani.
Adani's thing. But isme bhi there was a blanket thing they gave. Huh, you tell me about that. Yeah.
Yeah. So that SIT report was given. Now, just one more hearing took place. So the entire case was wrapped up in 3 hearings,
Right.
Meghnad. Three hearings, Vantara was cleared off,
Right.
of all these allegations. The third hearing, the last hearing that happened in the court, the SIT submitted its report on the 12th of September. 15th of September, the third, 3 days after that, submitting that report, the court takes up the matter. And the judges on the bench, funnily enough, say ki, oh, we did not go through the SIT report deliberately and we are opening it now before all of you. Open kiya, went to that very paragraph where they say that there is no violation of any law in acquisition of animals, and then they proceed to say, Justice Pankaj Mittal, ki we will accept the SIT report as it is. Now,
Wait,
just
I'm sorry.
imagine
Wait. Sorry. Okay, this is interesting. So SIT submits a report on the 12th, you say, right?
yeah,
15th ko they open it in front of everyone. They haven't even read it. They go to
yeah.
like an operative thing in the SIT where they are saying that Vantara is innocent. And then they
Yeah.
are like, oh, now we believe them. What?
Yeah, so that basically goes on to show that the judges had already made up their mind, and there was no scope of the judges actually disagreeing with any of the
But
findings of the
whatever
SIT.
happened to those 13 volumes then?
They were all submitted in a pen drive apparently, and that is now been sealed again in a sealed envelope. It was opened in the court, and the judges said that the judges wanted to make the entire report public, but Adani's Ambani's lawyer, Harish Salve, actually objected, and Tushar Mehta, the Solicitor General, also supported him, saying that there can be confidential information about trade licenses and blah blah blah. So therefore, please don't make the entire report public. So the bench agreed to it and made the summary of the SIT report public, which gives a fair idea of what it did. Anyway, that SIT report summary report was made public with the order. Now the order is also really objectionable and very suspicious, because the judges now because in court, what happened in court is also so blatant. The judges, क्या ये नहीं हो सकता था कि judges would have said कि we don't agree with this finding of the SIT? What was the process that they followed? By their own admission, if they haven't read the report, and they were opening it
It
at that
makes
very
no
point,
sense. If they have not read it,
it,
how will they know? Yeah.
there was no judicial application of mind in the case.
Also, sorry,
They
the
simply
speed is insane. The speed at which
yeah,
this has happened is insane. You're saying 15th, 14th August is when it started. 15th September is
yeah,
when it's over.
yeah,
In
absolutely.
literally a month.
And that's why it has become so blatant. Like there's no performative justice भी नहीं है यार.
Performative
And
justice
yes,
भी नहीं है.
and the final report is again so bad, because it says that Vantara, what it did was it gave Vantara a blank shit to just go against anybody spreading misinformation about Vantara. It says specifically that Vantara has all avenues in law open to them to sue for defamation, if anyone is found spreading misinformation
So
about the case.
essentially, what the
Now,
court did, sorry, if I understand this correctly, A, they gave them a clean sheet saying there are no legal violations. So all the
yeah,
reports that are pointing to those legal violations are false, right? The second is they actually told Vantara ki, oh, now you are free to sue these investigative journalists and activists and everybody else who is calling out your
yeah,
practices or violations. So in a weird way, what might happen is that Ambani, whenever it goes against any investigator or activist in Vantara cases, they can just use
yeah,
this judgment
yeah,
to back
absolutely.
it up कि saying कि अरे ये जज ने बोला है मतलब सुप्रीम कोर्ट ने बोला है कि
Yeah,
so
yeah.
then it's such a like a palla bhari side then suddenly.
Yeah, absolutely. Because of course, Vantara and Ambani's have that legal route. There's nothing special in it. Every person has a right to sue for defamation. But for the Supreme Court to say this so explicitly in a
Yeah.
judgment which gives clean chit in such a shady manner, just has a very chilling effect on any kind of future work against Vantara. What if there's new material on wildlife
Correct.
smuggling?
Correct.
Now that would be covered by this judgment of the Supreme Court, and the Ambanis can use that judgment before any court and say कि देखो हमें तो clean sheet मिल गया. This is exactly what Adani is doing, by the way, suing all these journalists. They are actually
That's
flashing
what
the
I was
Supreme Court.
coming to. That's exactly what I was.
हिंडनबर्ग को हिंडनबर्ग मैटर में हमें क्लीन चिट मिल गया
This
so
is
it has a chilling effect. Not just that, Meghna, the most consequential thing that the Supreme Court did in Vantara matter is to foreclose any future possibility of an investigation against Vantara, which is simply
yeah.
unheard. It's not it is not part of our criminal jurisprudence to do that. How can you? So the Supreme Court said that there no further complaints or investigations can be done on the basis of the same allegations, and they'll be covered by this judgment of the Supreme Court and the SIT's clean check. How can that happen? What if there's new material and somebody wants to investigate Vantara?
Yeah.
They'll be covered by the Supreme Court judgment. So how can you foreclose any future investigation? Last it happened was in the Judge Loya case, where our Chandrachud ji, authored that judgment and foreclosed any possibility of an investigation. So what was the tearing speed, the tearing hurry for hearing this case, constituting SIT, imposing a time limit so short on the SIT, and to foreclose any future possibility of an investigation against Vantara? What was the tearing hurry?
Yeah, I don't get it, but I mean, I want to bring in the Adani thing here, right? Because it is also so similar, but also very different. So Adani, from what I understand, with the whole allegations that were against them, etc. Paranjoy Guha Thakurta and a bunch of other journalists who have been for years tracking Adani. They've written literal books on them. They did a
Yeah.
bunch of reports in the EPW, and other organizations did a bunch of reports. And Adani wanted that to be shut down, right? So what happened?
So, like any other, person with so much resources, they actually filed a defamation suit against these bunch of journalists, nine of them
Yes.
actually, and the tenth defendant was John Doe. Now, John Doe basically covers any other person who's not specifically mentioned in that suit which they filed. So it restrains everybody else in the world from and they'll be covered by that order of the court basically. So that's a John Doe defendant. Now, so against those nine journalists, the Adani Enterprises alleged that they've been writing so much about the company, and that is actually making them. It's actually creating difficulties for them to raise money, and it is adversely affecting their company, and therefore they should be stopped from publishing anything allegedly defamatory against them, right? And for that, they actually listed many URLs that all of these journalists have published, writing on Adani's. Some as far back as from 2017, something from a year ago also, and told the court to, in the interim, in the meanwhile, pass an injunction order against them.
Basically, take them down.
Basically, take them down and restrain them from writing anything further which is defamatory to Adani, right? So the court on a Saturday actually passed an ex parte injunction order. Ex parte meaning without
This
hearing
was
the
a
other
this was a
side.
lower court, right?
This is a lower court in Rohini,
Rohini, yeah.
Delhi.
Yeah.
Now, when this was appealed before the district judge kept asking Adani's lawyers कि आपका jurisdiction रोहिणी में कैसे बन रहा है?
Yeah.
And Adani's lawyer said कि रोहिणी में ये lady है, वो lady ने call करके हमें बताया and therefore jurisdiction बन रहा है.
What lady hai? What?
कोई lady है जिसने ये पढ़ा and हमें call करके हमें बताया.
Sorry, so a lady called these people, Adani people, and said, ki, listen, I am not going to give you money. I'm not going to invest in your stock because of all these reports
Yeah.
from Rohini. Okay, go on. Funny already, go on.
Yeah, so they filed the suit in a Rohini district court, and on a Saturday, the judge district judge, not district judge, ASJ level ka tha. He passed an ex parte injunction order, basically telling Adani कि nothing more allegedly, which is allegedly defamatory to them, will be published by these journalists.
Right.
It restrained the journalists from posting anything about them, and also asked the Ministry of Information and Broadcasting and the social media intermediaries to take down all of the URLs that Adani had listed in his suit.
Yeah, and
And
a lot of them, right? Like, I mean,
a lot of them, yeah, a lot of
138 or something.
yeah,
Huh.
absolutely. And now that is actually a very sweeping order, because now you see, Meghnad, when an injunction order is being sought from a court of law, the Supreme Court and Chandrachud ji's judgment, which was actually great, it laid down the law in 2024, March or February 2024, in a case, and it actually said that the court has to satisfy three tests before passing an injunction order. Because injunction orders, especially on public interest reporting, adversely affects a person's right to know, right? And it affects the public at large. So the Supreme Court said that three tests must be satisfied. Number one is that there's a prima facie case made out
Right.
by the person asking for injunction. So basically, Adani. Number two, the balance of convenience has to be there. And number three, that if the injunction order is not passed, then it will adversely affect, it will lead to a significant loss for Adani.
Correct.
Now,
And you have
and
to
why?
prove that loss in court also, right? Like, I mean,
Yeah,
you
you
have to
have to. So
actually show कि story आने से पहले मेरा stock इधर था, अब now मेरा इधर है, and it is a direct
exactly, and the
consequence of
court
the
has
story.
to actually reason. It has to. It can't just mechanically say, "Oh, all three tests are satisfied." It has to reason why it thinks that the three tests are satisfied. Right? It
What
can't
is
be a
this
mechanical.
balance of convenience, by the way?
So basically, they have to balance both sides' interests. So they'll have to. So the judge was supposed to see whether, if it passed that injunction order, would it adversely affect the journalists, right? So
So basically
the
both
court said
parties shouldn't be affected. So in their attempt to fix Adani's reputation, then public
yeah,
interest and journalists shouldn't be harmed as a
should not
result.
be highly damaged, right?
Correct,
It
correct.
should not get greatly adversely affected. So all three tests apparently were satisfied, the judge found. Now, if you read that order, it does not give any reasons at all.
That's
It just
true.
says
I found it
because
very weird. Yeah.
yeah, and Adani in his suit is simply saying that markets will be anxious because of this kind of reporting, and it is leading to us not being able to raise money globally, and therefore it needs to be taken. It's all of their fears and anxieties in that suit being alleged. Now the court actually reproduces those fears and anxieties and says that, oh, a prima facie case is made out. Balance of convenience lies in their favor, and if this order is not passed, it is going to adversely affect them. It does not reason at all. And then it also, in the passing, just says ki public interest reporting, freedom of press, freedom of expression is there. However, any kind of reporting, this order will not cover actual public interest reporting.
But who
But at
decides
the
what is public interest reporting? Adani.
Adani decides, because
Yeah.
uh, after that line, the judge actually writes that Adani can also approach the MIB or social media intermediaries with further links, further URLs, and ask them to be taken down if they are allegedly defamatory. Now, who decides what is allegedly defamatory? It is Adani who's
Adani
been
who
given.
decides. Yeah.
Yeah, because the court gave that rolling
John
pipe.
Doe defendant.
Yeah,
So
John Doe
essentially,
defendant,
right
and not
now,
just against the
sorry,
journalists.
just right now, if we are talking about this case, it
Yeah,
can be a case of John Doe's talking about Adani and ruining their reputation by just talking about this case, and then our
absolutely.
URL needs to be taken down.
Yeah, or you'll have to expunge this part from your writing or your video.
Holy shit. Okay, so it is
Yeah,
basically reporting on Adani's banned now.
yeah,
Ha.
exactly. Which is such a surprising, unusual order. Never. Rarely do courts pass this order. They have passed it in the case, like some courts in Bangalore have passed such kind of
Gag orders.
sweeping orders. Yeah, sweeping orders against the News Minute and other media organizations. But it is usually unheard of. And how can, now when Adani came before the court and gave those URLs, the judge was supposed to open each of those URLs, read the report,
Yeah.
ask Adani pointed questions as to how this paragraph is adversely affecting you
Yeah.
and why do you want this injunction. But the court did none of that and instead actually asked those URLs to be taken down and also asked Adani to keep sending new links to intermediaries and get those new URLs taken
So,
down
so
and
two things,
act.
two things happened after this. One is which you said, which is the ministry basically was asked by the court to, or
Yeah.
Adani was asked to go to the ministry, and the ministry will help them take down these URLs, right?
Yes.
The
Yes.
ministry started acting on this very quickly, right?
Yeah, so I think after 10 days,
Yeah.
so September 6th, this order was passed. On September 16th, the MIB reached out to other journalists and also some of the journalists on that suit, asking them to comply with the court order,
Hmm.
right?
Hmm. Hmm. Hmm.
And gave a list of URLs, 138 URLs,
Yes. Yes.
for them to take down. Now, the ministry also, even though the court had directed the ministry to, take down whatever URLs Adani gives, the ministry can't act like a post office. It
Yeah.
has to apply its mind and see whether those URLs are covered under that order passed by the court. It can't be me giving URL on Ambani and
Mm.
ministry passing that as a post office to journalists and asking them to take it down. Now the ministry instead just passed on whatever Adani might have asked them to journalists and get it taken down. And I don't know, many of those journalists haven't complied. Some of them actually complied and took their videos down. Ajit Anjum and other people actually took down some of those
But they have
videos.
also like challenged it, no? I think
They have
Ravish and
also
people.
challenged it in a higher court, in a higher judicial forum. Some of these journalists appealed it before a district court judge, and the district court judge actually passed a very good order and asked very pointed questions to Adani's lawyers as to how an injunction can be asked for for an article published in 2017.
Hmm.
How can you ask for an injunction? Well, the injunction is for future
Right.
future and
Stories.
yeah, stories. So asked very pointed questions and actually lifted that injunction order against those four journalists. I don't think anything has happened for John Doe, which basically is all of us,
Us.
the rest
Yeah.
of the world. Yeah, I don't know if something has happened there. I don't think anything has happened on that front yet. Other journalists like Ravish Kumar and others are
And
also in the process.
Paranjoy and people have
Yeah,
challenged it in.
Pawan Roy also has challenged, but it was it was such a suspicious order because it
Listen,
doesn't
Saurav,
usually
okay.
happen.
Look, these two things, blow my mind because it has happened in like a sequence, right? It's just like
Yeah.
literally last 2 months mein ye dono ho gaye. And it
Huh.
concerns both, like A1 and A2, big
Yeah.
businessmen closer to the government, allegedly, all the things, right? Mujhe batao, now I am getting a feeling, and I'll bring in vote chori also here a little bit, right? The CCTV order, which is Mahmood Pracha goes to court, asks for CCTV footage from basically the election commission. Court gives an order to provide that CCTV footage, but then the election commission just changes the rules and
Yeah.
hides it. मुझे बताओ, is the court being weirdly used by the current administration to justify things that it cannot justify, and B, to preemptively change things that it wants to change just because the court says it?
I think in Vantara's matter, the government did not have interest. The government
Government
was
did not have
really not,
interest. Hmm.
yeah, the government was not really a party to any of that. Um, I mean, I don't know how much more I can say, but
I
on
mean,
a safer
I
note.
mean, on a like a, I don't have to be safe. I can just say. I mean, technically, the government is a middleman between me and Ambani, right? So I mean, like,
Yeah,
like,
yeah,
so anyway, so,
exactly,
but safer
exactly.
note. Go on.
Yeah, but in Vantara's matter, government did not have an interest. Whatever happened between them,
Yeah.
without the government's interference. In Adani's matter, it is a very strange case, and I think the court was really weaponized in a way
Hmm.
to serve Adani's interest, and that shouldn't have happened. And there has to be some course correction, and that judge needs to be hauled up and asked how he could pass such an order, such a poorly reasoned order.
Someone, Long John Silver in my community is asking, check the outhouse of the Rohini court judge. I don't know what that is in reference to. Do you know?
I don't know, but that judge was transferred a while ago
Huh?
within the district court because there were some adverse inputs about him.
Okay, okay, go on. Let's
Yeah,
not go there. Go on.
yeah.
Yeah.
But it's a very interesting case of weaponization of court. That kind of an order. So I mean, courts have been used for meeting such ends
Hmm.
in the past as well. But this is getting blatant, and that is what I've been stressing on since the beginning. That there is no performance. There's no performance happening at all,
Hmm.
because people's faith has to be maintained in the process. But if they just go on constituting an SIT and 18 days में वो काम करके दे रहे and clean chit मिल रहा है, um, it does not inspire any confidence, and they don't seem to care about it.
It's honestly like, I mean, of course, there are like these powerful people who just throw money at like expensive lawyers, get like quick hearings, like all the things, which makes me think of two things, right? One is this whole bail situation. Like, for example, someone like Umar Khalid and others in the Delhi riots, greater conspiracy case, are
Yeah,
there for
larger
now,
concept.
larger conspiracy case, are there stuck without any bail. The Koregaon thing, the Surendra Gadling sort of case, that is stuck for what, 6 years now, 6.5 years.
And a
Bhima
half year.
Koregaon and etc. Um, there are many other cases where bail is not being given. Mm, on the other hand, you have like situation where they're getting like quick judgments. Everything is happening so fast everywhere. It kind of erodes your faith, no? A little bit? No, actually a lot.
Absolutely. I mean, all these rich people with so much resources and political clout manage to get such kind of orders so quickly.
Hmm.
But a young scholar, so intellectually so bright, who has whose only fault was actually exercising his right to protest,
Hmm.
criticize and dissent, being jailed and incarcerated for so many years. Umar Khalid has been in jail for 5 years.
Yeah.
It sort of ruins your life because half your youth is gone. But the jail atmosphere also changes your psyche
Absolutely.
completely.
Absolutely.
He'll be a
And without
completely
trial
different man when
also.
he comes out.
It's not like a trial is happening. He's just there.
He's just there.
Yeah.
And he's there because Solicitor General Tushar Mehta, while arguing against his bail in the Delhi High Court, actually said that such people should be in jail until the trial is over. He made
Yeah.
that statement. And that actually shows the psyche of the present regime
Hmm.
also, right? Because they want the process to be the punishment, and
Hmm.
that is exactly what is happening. And the judiciary, which is supposed to be a bulwark against this kind of system and injustice, they seem to be fine with it, and not caring too much about it at all. Because even in the Delhi High Court, and I have tracked this case for a long time, the manner in which this was administratively handled, the bail pleas of these 9 Muslims who exercise the right to protest during against a CA and all of that, the manner in which the High Court administratively handled their bail pleas is
Please tell
also
us more. I think this is where the master of roaster also comes in,
master
right?
roster stuff. Because you see, the first Now, there were three other accused, so
Sorry.
who actually.
Before you go there, please explain what the master of roaster is for the audience.
So, Master of Roster is the absolute privilege of a Chief Justice to constitute benches of their liking and to allocate cases to the benches that it thinks is fit to hear that case, right? So, there is no guidelines to exercise that kind of power, and the listing of cases is also completely in the hands of the Chief Justice of that court.
Right. I will
So, in the
interrupt
High
you
Court,
just here, just a second, because ex-Chief Justice Chandrachud was asked this question by Saurav Dwivedi also. His response to this master of roster thing was that it's completely randomized. Right. Now, what happens is that he gave the example of some 70 cases are listed before 14 benches, so thousands of cases in a week. So it is impossible for a Chief Justice to actually allocate cases like this. It is a randomized number system that comes up. Where the Chief Justice does have discretion is when there is conflict of interest or something like, the judge will recuse
judge
themselves.
recusing or
And
something,
then
yeah.
they don't give any reason. They don't have to give any reason. They can just recuse themselves. What do you
Yeah.
think?
I mean that is the case. I mean there's random allocation of cases happening, but devil lies in the detail. Because if you read the Supreme Court's Handbook of Practice and Procedure, it says there's one rule which says that the registry has to send any case which is marked sensitive for the Chief Justice's order. So what is marked
Ah.
sensitive? We can't know, right?
Oh,
So
so
Prashant,
basically it can be as simple as, oh, this Vantara thing is very sensitive.
very sensitive. So they
So
mark it sensitive, send it to the Chief Justice for orders.
interesting. Okay, go on. So then give illustration of this whole system is the Umar Khalid case. Go on.
Yeah, is the Umar Khalid case, because just before that, like Prashant Bhushan has alleged that any case that he files is marked sensitive and sent to the Chief Justice for orders. So then the Chief Justice then sits and thinks, "Kya acha, isme." So the power is such, because it's there are no guidelines to exercise that power. The Chief Justice can actually pre-decide the case. अगर इसको bail देना है तो इस जज के सामने भेज दो, ही इज वेरी लिबरल. अगर इसको बेल डिनाई करना है तो सेंड इट बिफोर दैट बेंच इज वेरी कंजर्वेटिव व्हेन इट कम्स टू बेल. So the Chief Justice has that prerogative. It's not completely random when it comes to sensitive matters. And that's intellectual dishonesty for Chief Justice Chandrachud to say that in an interview.
And also,
Blatant lie.
one blatant, it is a blatant lie in a way. Even chat may the lawyers here are calling it a blatant lie.
Yeah.
But the other example of this was that whole Deepak Mishra press conference, no, like
Yeah.
2016 May, these four judges came out and they were complaining about this exact same thing, that the
Exactly.
Judge Loya case was selectively given to a particular bench, and
Yeah,
that is a
it
problem.
was Arun Mishra's bench, and Arun Mishra passed several orders in favor of Adani.
Yeah, yeah. Go on. So this Umar Khalid thing is stuck because of one reason is that there were benches like Bela Trivedi's bench, etc., who were giving, who were denying the
Would not,
bails. Huh, huh,
yeah, who were denying bail. So
huh.
basically, Umar Khalid and other people went to the lower courts. When matter is so sensitive, the lower court judges are very afraid. They say कि हम लोग dismiss करेंगे, आप ऊपर जाके देख लेना जो भी करेंगे. तो high court judges देख लेंगे, Supreme Court judges देख लेंगे. So the lower courts obviously did not give them bail, and that's a travesty of justice also in our country, because
Correct.
independence of lower courts is so bad. Anyway, it goes to the high courts, High Court of Delhi, and the first, there were three other accused who had gotten bail way back in 2021. Devangana Kalita, Asif Iqbal Tanha, and Natasha Narwal. Three of them together had gotten bail, and the bail judgment was great, because it actually watered down the UAPA and said that it has to apply specifically for terrorist activities. You can't randomly use it. Anyway, that order on UAPA was stayed by the Supreme Court. The bail was still, let it be. They're still out. The other accused, the nine Muslims, they went to the Delhi High Court, and the Delhi High Court, the first such bail plea was filed in May 2023, and in the next 4-5 months, everybody else also filed their bail pleas, and at that time, Umar Khalid's bail plea was rejected, and he then went to the Supreme Court. Now, when the matter was listed in the Supreme Court, the case was before Justice Aniruddha Bose and Justice Bela Trivedi. Now, the judge who issues the notice, and that is the rule and convention followed by the Supreme Court. The bench that issues the notice has to hear the matter until the end. So Justice Bose's bench was hearing it, which consisted of Justice Trivedi also, and he was supposed to hear it. But what happens is the registry somehow transfers the case before Justice Bela Trivedi's bench. Now, in the Supreme Court and in the High Courts, the lead judge, the presiding judge, has a larger influence over how a case is to be dealt with when compared to his companion judges. So, Justice Bela Trivedi was a former Gujarat law secretary in post Godra, Gujarat, under Chief Minister Modi, and was ultra orthodox, in the words of her colleagues, and was known to not give bail, right? And that matter being transferred to Justice Bela Trivedi's bench was highly suspicious. The registry does not have that kind of aukat to do something like that on its own. So obviously, the Chief Justice would have been consulted. It was in on his orders. So it was so Justice Chandrachud was consulted, and he passed that order to transfer the case. And now, before Justice Bela Trivedi, Umar Khalid's lawyers, obviously because they practice every day before the Supreme Court, they knew that they are not going to get justice before that bench because, for whatever reason,
Yeah.
so they sought adjournment. Perhaps with what hopes I can't comment, but then they sought adjournments. The state also sought for adjournments, and ultimately Umar Khalid's team asked to withdraw that bail plea and try their luck in the lower courts. So that is what happened in the Supreme Court. In the Delhi High Court, meanwhile, the batch of bail pleas were either being heard, but orders were not being passed, or benches were being changed frequently, which led to the entire
Further
bail
delay.
arguments being reheard all over again from scratch before multiple benches. And that went on and on. There were 4 to 5 benches which actually heard bail arguments from scratch. And ultimately, a month ago, I think, yeah, a month ago, the fourth or the fifth bench passed an order denying all of them bail, including Umar Khalid. So, which itself is, such a travesty because the bail plea was first filed in May 2023. You took more than 2 years to pass an order rejecting bail, and the Supreme Court itself, in many of its judgments, has said that bail pleas have to be heard within weeks. A
Yeah.
judgment has to be passed within 6 months once the arguments are concluded. But there was one bench in the Delhi High Court which heard both the sides but did not pass its judgment for 9 months.
Holy shit.
Until one of the judges was transferred to some other high court, which led to a fresh
Rehearing
bench
and
being
redoing of the whole
yeah,
thing.
exactly.
This is so
So
frustrating, man. Like, if you are someone like Umar Khalid or any of these people who are in jail, it must be so
yeah,
frustrating. I can't even imagine.
absolutely, and the law that they have been charged under, UAPA, is so draconian because even if you read the bail order of the Delhi High Court rejecting them bail, it entirely relies on protected witness statements. पुलिस ने 2-3 लोगों को पकड़ लिया, वो इंसान बोल रहा है हाँ मैं उस मीटिंग में बैठा था जिसमें
That's
उमर
true.
खालिद था, एंड उसमें वो लोग प्लान कर रहे थे कि हम लोग 50 लोग को मारेंगे. दूसरा आदमी बोल रहा था 50 नहीं, एटलीस्ट 150 लोगों को मारेंगे. बेसिस दोस काइंड ऑफ स्टेटमेंट्स
And
which
those
is
are all
not
like secret people. Those are like protected witnesses.
protected witnesses.
Ha, ha.
You can't know who they are. And basis those statements, the court actually said that it's a very serious case, and we believe that they are not innocent,
Hmm.
which is basically what they have to say to deny bail. They rejected the bill. Now these statements, Meghnad, when they go for trial, ultimately, whenever they do, 5 साल 10 साल बाद जब भी trial में जाएगा ये case, within 2 minutes, the case will
Fall
fall
apart. Hmm.
apart, because these protected witnesses will come before the trial judge, and Umar Khalid's lawyer will cross question them. They'll not be able to
Hmm.
justify why they said that. Jhoot pakad lenge, and the case is gone, it's over.
Yeah.
And the government knows this,
And
the
also,
Delhi
like, there are
police
like
knows
some
this.
very weird WhatsApp screenshots that were also a part of this whole thing. No, like
Yeah,
they were
just
in
because
some.
you're part of a WhatsApp group,
Yeah.
uh, you oh तुमने conspiracy कर दिया
That's why it's a
करा.
larger conspiracy, because of that
Larger
WhatsApp group. Yeah.
So the interesting part is Natasha Narwal, Devangana Kalita, they were also part of that WhatsApp group. Now, Gulfisha Fatima, who's one of the 9 people still incarcerated, Gulfisha Fatima also said, कि because they got bail, we should also get bail
Yeah.
because we are the accused in the same FIR, and my the allegations against me are very similar to those two
Hmm.
women.
Hmm.
Now, in order to deny bail, the judge who authored that judgment, that bail judgment, Shailendra Kaur, she writes, "Ki you guys created the WhatsApp group, which is very different from being part of that WhatsApp group."
What?
And they use this argument to deny Gulfisha Fatima bail.
Oh my god, that is so. Sorry, but like that's so frustrating to just hear about this. Is just like, क्या ही हो रहा है essentially.
And just imagine when Gulfisha would have read this bail order in her cell, what she must be going
Yeah,
through.
dude, exactly. That's what I'm thinking. Like, I mean, like, just to see, I would laugh, I guess. Like, after a
Yeah,
point, I guess that is the one way to go, which is like,
that would be one
I
way to
guess
cope,
this is what is
absolutely.
going to happen to us now.
Because would you cry over this? Would you laugh
I
over
think
this?
they
I
must
don't
have
know.
lost the will to cry, honestly. Now, I think
Yeah,
there must be like, they must be numb, and
it's such a
it's so
dishonest judgment.
sad. Yeah.
Such a dishonest judgment, holding on to straws.
Like even chat is saying they're getting very triggered just hearing about this. I absolutely agree. There is one a few questions, Saurav, if you have some time. KV is saying, how does the court determine if those witnesses are genuine? In case of public speeches, there may not be any video evidences to prove them wrong.
Now, see, the UAP is a very draconian law in that sense because one, there are two conditions to grant bail under UAPA. Number one, that the prosecution has to be heard mandatorily, which the court satisfied, of course. They wouldn't give bail without hearing the prosecution. Number two is that the court has to be satisfied that they are not guilty.
Hmm.
Now that's a big, requirement, because to reach that threshold, the court has to actually conduct a mini trial on its own.
Right. A
And
trial within a trial.
trial within a trial, because the main trial will take place after 10-15 years. So for now, the court has to say in its order that prima facie we think they are not guilty. Now imagine a UAP accused, terrorism accused, and a district court judge, making that kind of a statement in his bail order. It's a big threshold to
It is.
pass.
It is.
So therefore, what the court actually then does is go through the material provided by the prosecution, by the investigating agency, and just take a cursory look and say, "अच्छा इसमें allegations ठीक लग रहा है, सही लग रहा है, there is
Hmm.
material," and therefore say कि prima facie we think that the allegations are serious in nature and there is substance to it, and we can't say that they are not guilty. That is the
Right.
threshold they have to reach.
Right.
But a constitutional court is also empowered to grant bail if there is prolonged incarceration. This
Hmm.
is a very good judgment that the Supreme Court had passed in the
Right.
Najib case. in 2021, right? So the Supreme Court and High Courts can grant bail if there is prolonged incarceration. And in their case, definitely there is prolonged
Oh,
incarceration.
of course there is. Yeah.
And despite that, the bail judgment says that we considered prolonged incarceration, but it is not a right. Courts are not compelled to give
अबे
bail just on the account of prolonged incarceration.
but jurisprudence तो है ना.
Jurisprudence hai. So see, the bail in
Also,
such
bail is a
cases.
right.
No, bail is not a right.
Okay.
Bail in such cases is a discretion that the judges can exercise.
In case of UAPA type situations.
UAPA, or
Because the
even
law
heinous
is
crime.
being changed to do that. Yeah.
Yeah,
Yeah.
heinous crimes also.
Yeah.
Bail is not a right; it is a discretion,
Okay.
right?
Got
So
it.
the judge has to clearly, but that discretion cannot be unguided. There is a jurisprudence, there is a philosophy that courts follow, and that philosophy is that bail, not jail. But in these kind of cases, Umar Khalid's case, and several other cases, the courts operate in a way which says jail, not bail. But
It's the same
so
thing, right? The usual thing is innocent until proven guilty, but because of
exactly,
UAPA like laws, it is guilty until proven innocent. So
yeah.
the
But the
burden
courts can
of
still exercise the discretion
yeah,
because
and the burden has been shifted on the people who are incarcerated. Basically,
incarceration,
you
absolutely,
have to prove that you are
that
innocent.
you're not a
You're
terrorist.
not a terrorist. Yeah, the
Which,
government is saying you're a terrorist
yeah.
without any whatever evidence, like bol diya bas, and you have to prove that you
Yeah,
are not.
there's a media report. Scroll did an investigation on the charge sheets that Delhi police has filed
Yes.
in the larger conspiracy case, and they tracked down two of these protected witnesses, and they went and asked them, "आपने ऐसा statement दिया क्या पुलिस को?" And the protected witnesses are saying, "हाँ जी, हमें तो प्रेशराइज किया, हमें तो कोर्स किया, इसलिए हम लोगों ने ऐसा statement दिया." Now, if they would have said the same thing before a trial judge, the case would have
Yeah, it would have just
crumbled.
gone. Yeah. See,
Yeah,
that is another reason why I think they don't want it to go to trial because the process becomes the punishment now. Is
exactly.
as good as they are in jail now. Plus, unka lawyer पे पैसा लग रहा है.
And the High Court judges know this very well. Coercion of witnesses, yeah, these prosecution witnesses, कैसे witnesses को लाते, they know this very well. They see this day in and day out. So therefore, it's a dishonest judgment because Shailendra Kaur, who authored that judgment, and Naveen Chawla was the other judge who agreed with that judgment. They knew कि once this matter goes to trial, it's going to crumble, and therefore there's a prolonged incarceration. We can exercise our discretion and give them bail, but they didn't choose to exercise their discretion. So it's dishonesty.
No, absolutely. Okay, there are more questions. Disha is asking, in context of Vantara judgment, does business sir now enjoy greater benefits than USA libel laws as well? Sorry for repeating. Yeah, but she's curious. Yeah.
In I mean, it's just that when the Supreme Court has given you the clean sheet and has so explicitly written it in a way that sends a chilling effect, it is a greater privilege than the US law because then they can flash that order. No trial court judge is gonna say no to you because there's a Supreme Court order. So it's a great privilege
Yeah.
for Adani.
It is. I mean, see, that's what I was also thinking that, like because of these orders, like the Vantara thing and the Adani thing, it's almost like the court is becoming like a shield of sorts. Like
Yeah.
people are going to court just to gain that shield. In video games, you have this, no? Like you have a health bar, and then
Yeah.
sometimes you collect these power ups which will give you like a shield bar. I feel
Yeah.
like the judiciary has become like a shield bar for a lot of people, which is
Yeah.
like अभी health पे attack हो रहा है, अभी फिर shield
हो
bar
रहा है.
pick up करेंगे तो फिर there extra protection मिल जाएगा.
Yeah.
And honestly, one of the things which I think I touched upon a little bit, I think I can ask you this as well. The whole vote chori thing, right? A lot of people have been asking Rahul Gandhi to go to court. right? My view is that he should not in any circumstance go to court, because it will be the adverse effect. Now it almost seems like going to court is to your detriment. Do you feel
Yeah,
like that also?
absolutely. I mean, the issue is, once it goes to court, it becomes a sub judice matter.
Yes.
Once it's a sub judice matter, you can't discuss it in parliament as well.
That's true. I mean, you
And
can technically, but like people just keep using this sub judice thing
sub
as a
judice,
thing. Yeah.
you can, but then the government would not want you. You'll also say कि matter court में है तो क्यों
Yeah, yeah.
comment करना? Because people don't generally comment on sub judice
Yeah, yeah,
matters.
yeah.
And the number two effect that it would have is, given the kind of judges that we have now, and given the political implications of any kind of order that is passed, it's best that this is fought out before the electorate. There can't be a greater judge than the electorate in a country. And these are matters that you need to fight on the ground politically, not in a court of law. I mean, a court of law, you might want to fight it on a single case by case basis, but going for a larger SIT kind of an investigation, I think usse to bachna chahiye, and I'm very glad that they did not even consider this option.
Like, I mean, see, here KV is also asking, then from terrorism to anti-government protest organizers, the UAPA seems to be covering a lot of ground. Can the law make any distinction? Exactly what KV is saying, right? Which is the government has made laws in a way that A, getting bail is very difficult. B,
Yeah.
whenever you go to court, it almost seems like the court will give an adverse judgment, doing things like this master of roaster thing, or giving you an unfavorable bench, or even
Yeah.
like giving like these blanket, like like farmans of John Doe
Yeah.
or whatever.
Yeah.
It's just a bizarre situation to be in as a democracy.
Absolutely, because UAPA kind of laws are special laws. They are called special laws.
Yeah, yeah.
Special for a reason, because you can't invoke it for just doing a chakka jam outside your house or something. Because it then frivolizes the law, and it takes away, it strips it of the seriousness that it deserves. What if there's a genuine terrorist in the country
That's
and
true.
you want to charge them specially?
That's true.
Then people are not going to believe you. Like, you cry fox all the time, then when the fox actually comes, what happens?
That's actually very true. Like special laws should be used in special cases. That's as easy
Special
as that.
cases. Yeah.
Rim Jim has a question for you. While we talk about this, can you tell us a few judgments that made you go, there is still hope? Sorry, just before
Nice.
you answer,
Yeah.
I feel that the people who are anti-establishment, people like me, people like a lot of people, whenever they get like judgments like the Waqf thing or the right to privacy or whatever, हम बड़े खुश हो जाते हैं. Then the next 10 judgments would be against the people, against the citizens, against the everything, and then the judiciary would give another like tiny ass judgment which everybody like क्या बात है, amazing, amazing. Do you think this is a pattern at this point? Also, like, please answer Rim Jim's question.
Absolutely, because I don't, one of the complaints that lawyers have now, and I talk to a lot of lawyers on a daily basis.
Your literal job,
And
yes.
yeah, my literal job is to talk to them, and I'm getting flooded by messages from High Court saying यहाँ पे ये हो रहा है, यहाँ पे वो हो रहा है. I have become like the harbinger of judicial bad news for
It's good news,
for
Saurav.
this.
The reason why I have to praise you here, because the reason why I think I love your reporting and your commentary is that you give zero fucks, which is amazing. It's like one person who will get contempt of court is Saurav. मैं तो wait ही कर रहा है, but कभी आया नहीं है तेरे पे, which means you're doing a great job. So go on, yes.
Yeah, but what was I saying? The question was on
Rim Jim was asking,
good
are there any cases which you think are giving you hope?
Yeah, yeah. The problem is that we have a very polyvocal Supreme Court. There are 17 benches hearing similar kind of cases day in and day out, and every bench has a different view. So there's no following of a single precedent, and that's the complaint that lawyers also have. that the judiciary, the judicial decision making has become very judge centric. So it depends judge to judge. आपने जज को खुश कर दिया तो आपको एक काइंड ऑफ जजमेंट मिलेगा, इंस्टेड ऑफ कि प्रेसिडेंट के बेसिस में होगा कि पहले ये डिसाइड हुआ था तो इस केस में भी वैसा ही होना है. वैसा सिस्टम नहीं बन रहा है. नाउ इट इज बिकमिंग, इट्स अ फ्री फॉर ऑल, कि
Or they
ये
will
जज को
just
खुश कर दिया.
yeah, or they would just like follow the normal law, I guess, or the process
Yeah,
or
yeah,
evidentiary
exactly.
value. Yeah,
Exactly, because we are a common law country.
yeah,
We follow precedents.
yeah.
What the court decided in 1970, 1980, 1990. We follow that and build upon it, develop it to suit our times. But what happens with the polyvocal court, and what is increasingly happening even at tribunal level, even in high court level, is that the judge is saying, "Acha, wo judgment does not apply to the case before me," and therefore goes on to order whatever they want. And therefore you see these kind of judgments where they pass a right to privacy, but at the same time pass Judge Loya, pass Kashmir, pass uh,
Ram Janmabhoomi
Ram
and all these
Janmabhoomi,
things.
Ayodhya,
Yeah.
all of that. Yeah.
No, and
So even in
I
even
think
in
you're correct.
the
I feel like it would be wrong to see this whole system as a monolith. Also, sometimes
yeah,
like it's all about discretion at the end of the day with the
yeah,
collegium system and with the master of roster. So
with the
essentially, like the
master.
cases that the government is interested in, the CJI will take interest in it and then
Yeah,
manipulate it in a way that it goes to like particular benches, which
yeah.
ensure a certain kind of verdict because of the judgments, which are the conservative judges, whatever you want to put it. And the
There's
other
no
thing,
robust checks and balances, Meghna. That is
yeah.
the bar has to be the check on the bench. That has
Hmm.
completely failed.
Hmm.
Then you have, a two-judge bench passing a judgment, but a three-judge bench staying a two-judge judgment, even though the rules don't allow it.
No, and
It's
one
an
of the things,
intra-court appeal.
Saurav, the reason why I feel like another reason why so many people come to you, like lawyers keep coming to you, is your commentary is also about the judicial system at large, right? Like you explain the rules, you explain master of roster, and that is why this is happening. So you connect a lot of dots, right? Essentially, what I did with Parliament, you're doing it with courts, right?
Yeah.
Initially I remember when I was covering the Parliament as an institution, both of these institutions are extremely intimidating for normal people to understand, right? And I
Yeah.
feel like it is very important for people in the media and journalism or YouTube to also like break down these things properly and explain
Yeah.
to the people so that they're less scary.
Absolutely.
Yeah. Do you feel scared sometimes that like is someone coming after you, is the justice system coming after you? Because honestly, like it takes balls to do this. So do you get like threats? Do you get like intimidation? Whatever?
Fortunately, so far I've only gotten one legal notice from a sitting Supreme Court judge asking me not to publish what I wanted to publish.
Hmm.
But other than that,
Preemptively.
sorry,
Preemptively.
preemptively, because I had sent a list of questions to him as his
Okay.
right to respond,
Okay.
and that happened. But other than that, legally, nobody has sort of threatened me from the bench. But I do, I mean, there's some amount of self censorship that also is happening now, because you can't displease everybody,
Yeah.
but the
That's
issue
true.
is that there are too many people who can be displeased, and that's the tragedy of our system. कि तुम्हें अगर there are 20 judges, there are 17 worth displeasing.
Right. Right.
So
That
what do
makes
you
a lot of
do?
sense.
Do you, and that's the dilemma that I usually face. Ki, should I displace two of them? Then what about the four others who are doing the same kind of job?
Mm, mm.
क्या करोगे?
Yeah, you're doing triaging essentially in a very strange way.
Yeah.
But thank you so much, Saurav. And anything you want to promote, any story we should look out for, anything else?
Uh, yeah, I'm working on one important story
Okay.
again related to the Supreme Court. So yeah, I'll be very happy if we meet again once that
Yes,
story is
after that
out.
story is published. Yes.
Yes.
When is
Yes,
it coming
and
out?
I don't know. I don't know. Maybe a few months.
Okay, like a long form you're doing, long
Long
form.
form.
Are nice, nice, nice. Very nice. And also like so you have started writing for the Frontline. You
Yes.
have a column in Frontline now.
I have fortnightly column with them, with some
Yes.
special columns coming out whenever there's something very urgent.
Yes. So I'm going to
So
put a link for that as
yeah,
well. And
yeah,
please follow Saurav on Twitter. He's very active there.
yes.
And yeah, thank you so much, Saurav. You've been amazing. And thank you for coming again.
Thank you, Meghnad, for having me, and I look
Yes.
forward to coming to your show again.
Yes. And
And
also,
thank
like,
you
please,
for
Saurav,
giving
if
people like
you
us a platform.
see, this is exactly what I was coming to, Saurav. Please use me, man. Like sometimes when you are like panicking, sometimes you're like, oh my god, holy shit, कुछ तो हो रहा है. See, you panic yourself. You're like, oh my god, shit, ये हो रहा है. But
Yeah.
that feeling needs to come to us also, no? तो please call me and please come.
Yes,
Like मैं
absolutely.
तो
I'll do that.
week में 3 बार stream करता
Let's
ही
all
है.
panic together.
Yes, exactly. मेरा community और तू और मैं साथ में
Yes.
बैठ के पैनिक करेंगे. Okay.
All right.
Okay. Thanks, man. Thank you for being
Thank
here.
you, Meghnad. Bye.
Bye
Bye.
bye.